What you don't know can hurt you, and what you do know can set you free. That's why we interview subject matter experts for your small to medium-sized business and personal finances, because knowledge is power, but experience is everything. Welcome to The Tipping Point. The Tipping Point is brought to you in part by Tirani & Velez, LLP, your tax and accounting subject matter experts. Welcome to the show, everybody. I'm your host, Gabriel Velez. Our guest today is Mike Walsh, trust and estate attorney at the law office of Michael T. Walsh. Mike has served Orange County for over 35 years. He is a certified specialist in estate planning, trust, and probate, as designated by the State Bar of California. Furthermore, he has vast experience in business planning, asset protection, and post-marital agreements. Welcome to the show, Mike.
Welcome, Gabe. It's a pleasure. It's my very first podcast, so I'm looking forward to this.
Oh, that's awesome. So thank you for being on with us today. You have so much knowledge, a breadth of knowledge, both in estate, tax, business, et cetera, et cetera, et cetera. But today we have you on really talking about, estate and trust and how everything feeds into the estate and the trust. So
time tends to do that to you.
It's the inevitable, right?
You do it every day and you learn something.
It's the inevitable. Yeah. Well, maybe we're talking about two different things. I'm talking about the inevitable.
Well, life as well as profession.
Yeah.
So
aside from the obvious that we're all eventually gonna leave this world, what is the purpose of estate planning? And let's start with the guy who doesn't have a family, doesn't have any heirs, and why would that individual need estate planning?
Well, the very first thing is estate planning is not just about dying.
Okay.
So essentially, if you have an interest in taking care of yourself, now what else could happen to you other than death in life?
Incapacitation,
accident,
illness.
illness,
Yep.
Crime. So many things can happen to you where you just sort of lose your ability to do things for yourself.
Mm-hmm.
And essentially, you've got to make some choices to set up something where you choose who can take care of you and take care of your affairs. Someone who you trust and someone who will do the job, and do the right thing by you.
Yeah.
So that's very important for a single person. And it's more important when you don't have any, as you said, heirs or you're not married, you have no kids. I'm assuming you mean you have no parents. So if you don't have anybody who would just step in, but that person can't just step in. That person has to go to court. If you're over 18, that person has to go to court and ask the court for power to do something for you. It's called conservatorship. Okay. Conservatorship of your physical person, conservatorship of your property. So that third parties have somebody to deal with. So essentially, estate planning covers all those situations where you're not able to do something for yourself and you want to make sure that you're taken care of.
Yeah.
Okay? Otherwise, you're throwing yourself on society, adult protection services, the courts, appointing some stranger. You read about these stories all the time. So the very first part of estate planning is to take care of yourself.
Yeah. So for that guy, that individual, hypothetically, who would make a decision for them if is it just people coming out of the woodwork? Any next of
Well,
kin?
if he doesn't choose somebody?
Yeah.
Well, if he doesn't choose somebody, the court's going to appoint somebody.
Okay.
I mean, there might be a friend, there might be a neighbor, there might be someone who's close to who goes to the court and says, there's nobody else. Let me, sign up to take care of Joe or Susie or whoever it may be. But that's a costly process, and a lot of people aren't going to want to get involved in it.
Yeah.
So it might just fall back on adult protection services.
Okay.
And so the county essentially you'd be throwing yourself on the mercy of the county.
And that's probably not a good idea.
I wouldn't choose that. I mean, gee whiz.
Yeah.
But the probate code, and you've seen this book before. I'll hold this up.
Yeah, it's a large book. What's
and,
that, about 1,000 pages?
Book, I don't know how many pages in, but look at the fine print.
Yeah.
Anyhow, this book governs what happens to you if you haven't done things for yourself.
Yeah.
Whether it's during your lifetime or at death. So essentially, what I say to a lot of people is, you have a plan whether you know about it or not.
Yeah.
And if you haven't done anything, your plan's in here, and I dare say you've read it.
Yeah.
Okay.
And
So then you move up from that circumstance. You're talking about a person who basically is on his or her own.
yeah.
Okay, from that point, which also I'm going to maybe jumping ahead of myself a little bit, but every parent who's got a child who's over 18 has the same sort of problem. They're making decisions, they're involved with their life up to the day their 18th birthday occurs, and all of a sudden they move out of state, go to school. Things can happen to them in another state with respect to, I'm not looking to a death, that's an easier situation to handle, the parents inherit. But from the standpoint, of handling their financial affairs, whatever, their health care, that's very important. Who's going to talk to you over the phone? Now, one of the things that may bring this point home is the fact that we had that Pulse nightclub disaster in Florida. There had to be a waiver from the president to allow people to call in and deal with the hospital because, as you can imagine, young adults probably didn't have anything in place like a healthcare document.
Okay. So estate planning is for everybody. Well, it's not just for your heirs.
You don't have to have a lot of property to have estate planning because even if you have a small amount. Now, in California, we're pretty lucky.
Okay.
We have something called a small estate. I'm jumping to death right now.
Yeah.
We have something called a small estate affidavit. And if you have less than $150,000 in property as of the date of your death or the date that this is done, someone can come in and say, you know what, I'm really entitled to that property, whether it's under a will or under a trust, without going to a full probate. Okay, so that essentially what happens is that the courts and the legal system and all the third parties that you're dealing with, big institutions, banks, you name it, this is not a world where you know everybody anymore who handles your person or your property. So essentially, law says very simply, you put something down in writing, you do it right, you do it clear, you sign, date it the proper way with a witness or a notary, we'll honor it. It's that simple.
Yeah.
It's not scary. It's addressing something that we all face, risks. In everyday life, when people look at their car, they have car insurance. Their house, they have house insurance. Their health, they have health insurance.
Right.
Business continuation insurance, E&O insurance. I mean, you go on and on and on. But this is your physical person and your physical property. That's pretty important.
Just as important as anything else. So
or more.
Yeah. So what you're talking about in memorializing these things are trusts and wills, right?
Well, actually, the very first thing would be powers of attorney.
Okay.
A power of attorney, and a lot of people use this expression, he's my power of attorney. Well, he has your power of attorney, but he's not your power of attorney. There's a legal definition everyone understands, but he is my attorney in fact. That's the legal term for a person who can do something for you based on a legal document called a power of attorney. So anyhow, just putting that aside because people use that all the time. He's my power of attorney. So, but the very first thing for everybody, and I say this is the most important document you have, is the fact that, who can take care of all of my financial affairs in the event that I'm unable to do it for a short period of time or a long period of time. And number two, who can make medical decisions for me if I can't do it myself?
Yeah.
And you can imagine on a whole set of circumstances, I could regale you for hours with times that these would be needed even for a short period of time. Now, also in the power of attorney, you can say, hey, you can create a trust for me. Hey, you basically got it from I'm involved in a lawsuit, which could happen with an accident. You can pursue the lawsuit for me. You can settle that lawsuit for me.
Yeah.
I mean, I dealt with people who are really in a bad way. There's a lawsuit. Now there's nobody to deal with the other party in the lawsuit.
And there's nobody really other than the estate attorney that has those conversations.
Well, if you want to do it on a thorough basis, you want to do it with someone who's been around the block a while, who's seen a lot of different circumstances, and then can give you advice and guide you from the standpoint of what are your risks and what are your choices, and then document that in a clear, proper fashion. Otherwise, if you go do it yourself, pull the standard California form off the internet, go to LegalZoom, whatever, essentially you're not getting that guidance. And that can make all the difference in the world.
Well, yeah. I mean, lack of experience, right? You've seen many probates. You've seen many trusts have to or be fought over by heirs. You've seen a lot. All that experience comes into play when drafting a document.
Well, essentially, one of the things, it's one thing for a person to go do estate planning, but essentially, and I have them reading their documents multiple times before they sign them, ask me any questions they may have. But one of the things I find quite often is documents that are very poorly drafted. And the problem with a poorly drafted document is that a third party may say, I don't understand this, I don't get it. It doesn't say that you can tie your shoes on Tuesday mornings. But on the other hand, it's more important when you have family matters, or you might have some conflict in your family, that things be clear. If you're part of a large family, you may not trust each person in the same way. You might trust one person for a healthcare decision, whereas you might trust somebody else to handle property. And then you might look at all kinds of their own personal environment. Maybe they're going through a lot in their life, and they don't really have the time to do this. So there's a lot of considerations going into choosing, first, what do you want to do? And then secondly, who do you want to do it?
Right.
Okay, so I say this all the time to people. Make it easy for someone to help you. And that's deeply appreciated by the person who has to do the job.
Yeah, the last thing you want to do as a successor trustee is open up a can of worms where people are trying to sue you because there's a bad interpretation of a.
Well, if you've got people that don't get along with each other,
yeah,
they're all going to look at any document, particularly a trust or will, and read it from their standpoint. But he said this or she said that, and I remember, and I'm looking at this. That doesn't say that to me. Okay, so being really, really clear as much as possible, you're doing everybody a favor, because not only do you want to come up with an estate plan that covers everything we can anticipate, not there's not going to be something that falls through the cracks, but essentially over time you can anticipate most things that can happen. So it's not just your assets taking care of you during your lifetime. Who do you want it to go to? How do you want it to go to them? Because not every beneficiary has the same circumstances. Some may have special needs. Some may have, issues with creditors. Some may have issues with the IRS.
The IRS. Yeah.
Okay?
Yeah.
Some may have a lot, and a lot of times if you're going to be giving your money to somebody, well, I'm not giving it to them. I'm not giving it to your creditors.
Right.
Right? That's not the purpose that I worked my whole life. Okay, but so when you can actually, when I look at an estate plan, not only do I want it to be thorough, in other words, who are you? What are your relationships? What do you have? What do you want to do? And here's some choices. And may not be good at what about this from experience. But essentially, the last thing you want to do in the drafting is you want to make it as black and white as possible, so that you've got people who are looking at it from their own personal perspective, and they're saying, well, I don't think that's fair. Okay,
yeah.
I should be getting more, not less. Okay, so essentially, you want an estate plan that works, that works with the government, that works with banks and brokerage houses, insurance companies, and it works with the people you've named and the people you haven't named.
So let's back up a little bit, because some people might not know, like the structure of a trust, or there's a lot of names for your regular living trust. Right.
Correct.
Living trust, grantor trust, revocable living trust, right?
Yes.
All these terms, and for most people have that type of trust.
There is a bit of confusion.
Yeah.
I do think, and I'll tell you why in a second. I do things very simply.
Yeah.
So if I were doing a trust document for you, the Gabe Velez Trust, you're an individual.
Okay.
Or you're married, which I happen to know. It would be the Velez Family Trust. Something that's really simple. Why is that important? Because it's easy for you to remember it.
Right.
Okay? And then you put a date on it. But essentially, I've come across documents which would have the Tom Jones and Mary Jones Revocable Living Trust dated such and such a date.
As a title.
That is the title. And then sometimes we're not sure exactly what the title is in the document. Because after something happens, it could be irrevocable and it still has the word revocable in it.
Right.
And then how do you create names for any subtrust you might create? I like simplicity. I like something that a person could remember without thinking. Okay? So a lot of times when I'm drafting a document, how do I make it easier to read? These are not everyday concepts. So before I get to that, I'm going to say one thing. A lot of people, they've heard the word trust. They've heard the word revocable. They've heard the word irrevocable.
Mm-hmm.
So what is a trust? I'm going to answer my own question here. This is what I'll say to people. What is a trust? You've all heard of trust. Just go back to the Statute of Elizabeth in the 1500s.
Okay.
And originally they came up from the standpoint that some clever lawyer at the time said, if I put this property in an entity, and then I say it goes to you for life, and then it goes to your son for life, and then it goes to his son for life, etc., etc. This could go on forever, and there's no change in title on the real estate records.
Yeah.
Okay, of course that happens a little bit today too. So they came up with something called statute of uses. So essentially they ignored the legal title and said if something changes, which is exactly what we do with property taxes.
Right. Yeah.
Okay, we look at, okay, who's living, who's benefiting from it? That person's gone. We got a new person to deal with. Are you entitled to an exclusion, or do we just keep this rolling forward? Okay, so essentially a trust is very simple. If I hand you $1 and I say, Gabe, take care of my sister with this $1.
Mm-hmm.
Okay, so what do you do with the $1? You invest the $1. You got title to the $1 because I handed it to you. Okay.
Yeah.
Now I've told you what I want to do, sort of. Maybe it's going to be in writing, but I told you what I do. And then if you can't do it any longer, then somebody else takes your place. And if they can't do it, someone else takes their place. But essentially what I'm doing is I'm splitting up the control of the asset from the person who has legal title to the asset. So you're getting it for a purpose, not to benefit yourself, but to do a set of instructions. So we name somebody and we split that $1 into the legal control from the beneficial control. And that's all a trust is, and it's dressed up from that point forward.
Yeah. Okay. So breaking it down, that what you're talking about is a trustee versus a beneficiary, right?
That's correct.
The trustee is basically the manager of
a
the
manager,
trust.
that's correct.
Yeah.
And he or she is given a whole set of powers, both in the probate code, but generally you want to state your powers in the document because you don't want third parties going to look and say in the probate code. So essentially you say, yes, you can buy, you can sell, you can exchange, you can enter into an agreement. So you give that person, it's delegated powers.
Right.
You as the owner have all those powers. If the thing is your asset, you can say, I'll sell it to you, I'll give it to you, I'll destroy it, I'll do whatever I want. But when you delegate that to somebody else, you've got to say, yes, I'm putting you in charge, and here's the various things you can do with that legally, and here's what I'd like you to do with it beneficially.
Mm-hmm.
Okay, so you want a very thorough set of instructions in there, but you want to choose somebody, but you want to leave flexibility in the whole process because we can't anticipate everything. I mean, I build doors and windows, like I say, into my trust, allowing some things. I had a call the other day from someone, and we had set up a trust. I'm sorry.
Oh, you're fine.
Okay, we had initially set up a trust for a husband and wife moving here from out of town.
Yeah.
And one of the daughters, out of the two daughters, was married to a guy who had a lot of IRS tax problems.
Okay. Yeah.
So we created a trust for her for life because we didn't know how long she was going to be married to the guy, and we had discretionary income and discretionary principal.
It's okay. You can keep talking.
Okay. So essentially, I just got a call from a lawyer for this daughter saying, I divorced the guy. Now I'm stuck with this trust. Now, we couldn't say in there the purpose of the trust, but we know what the purpose was. So I went further and called her back several times and said, oh, by the way, I've got a little power in the back of this trust allowing the trustee the right to make amendments under certain circumstances. She goes, oh, I didn't expect to find that in there.
Yeah.
So she never even looked. Okay. So essentially, having some escape hatches in these documents because of changed circumstances is really, really important. I've looked at some documents that could be poorly drafted, well drafted, but if there's no escape hatch for the future and you're doing something that's going to last a long time, somebody's lifetime, you've got to think ahead,
Yeah. What you were just talking about is more of a irrevocable type trust, although it's not.
Well, it becomes irrevocable on an event. If the person who created the trust can't change it anymore, they're incapacitated or they've died.
Yes.
Mostly death creates an irrevocable trust because there's always hope springs eternal that you might recover your powers. So you can create a trust as an irrevocable trust, but that's done less and less these days. It's done generally for tax purposes. It used to be done for estate tax purposes, where you would create, for example, a life insurance trust, so that it was set up there for your beneficiaries, but you didn't control it anymore. So therefore, it wasn't put into your taxable estate. Or you could create an irrevocable trust for a charity, one or more charities, where you get some tax benefits that tend to be used more and more these days for things that are tax related, but they could also be created for a person. Let's say you've got a special needs person, that where you want to basically lock it up for their life and make sure they're always taken care of. The irrevocable trusts have their purposes, but most trusts we do are revocable trusts meant to bridge death and going to somebody else without going through probate. Okay? So you know what probate is. Probate is a process where you bring in your documents, a will, that's published, and everyone's given a copy of it. Someone's named as executor. Somebody waives bond. Very good, very important. And the court follows that and supervises the process for maybe a year and a half. And it costs money to do that. There's filing fees; they're going up all the time. There's attorney's fees. There's accountant fees. There's an executor's fee. But if you walk into the court and you don't have a document, now this becomes your will. It's called dying without a will is called intestacy.
Okay.
And there's a whole set of things. Who inherits in the event of intestacy? It's all spelled out. Okay? So if you have no will and you have no trust, this is your will.
Okay. So probate is a process where the court basically takes control over your assets and decides who gets it, right? Basically.
Well, they either follow the will or they follow the intestate code in the California probate code.
Right.
But they supervise the process to make sure it's done right, and then they wrap it up and make sure it gets wrapped up within a reasonable period of time.
The only way to avoid probate is to have things in a trust.
And that's not the only way to avoid probate. For example, let's assume you had nothing but one big life insurance policy, and you name someone the beneficiary. Well, that would never go to probate, assuming the beneficiary survives you.
Yes. Well, because that's controlled by another document, which is the contract with the life insurance
Right. The document itself has its own provisions of beneficiary designation. So you could have that on a bank account. You could have that on a brokerage account. You could have it on a life insurance policy. You could have it on a retirement plan. So essentially, you could own an asset and say, you know what, I'm just going to put your name on it with me as a joint tenant. And that person,
with like the right of survivorship.
Exactly.
Yeah.
Or what they call a revocable transfer on death deeds now, where you can actually say who you want it to go to, but you can change it. So there's a lot of ways to avoid probate if you do it in the document.
Yeah.
Okay?
Okay. But it has to be in a document.
It has to be. Everything's got to be done by the book.
And a will does not suffice as that document, because the will is going to go to the court.
The will has to be supervised.
And
proved. Probate is proving the will and going forward with that.
That it's real.
That's right.
Okay. So that's probate. Probate's first off, it can be an expensive process, right? And it's a very public process.
That is another big thing that people don't think about, because everything that goes through the probate process is public. It's available for anyone to look at. I mean, a lot of famous people have died and had a will, like Jacqueline Kennedy Onassis. I mean, you can look and see what she wanted to do with everything. It's in the will.
Yeah.
Okay, so a lot of people today, and people today you've got identity theft going on. You've got a lot of issues where you may not want your brother-in-law or somebody else to find out what's going on, or whatever it may be. Creditors, etc. You may not. So a trust is a great way of keeping everything private, making it immediate, so you don't have to wait for this whole long court process, year and a half. It takes time with the trust, but the person is in charge immediately without having to be proven. Okay? So it does a lot. There's a lot of ancillary benefits, not just saying who gets your stuff, how, when, where, and why, and avoiding probate, but there's a lot of practical side benefits from the privacy and the immediacy.
How about people who own either a small business or they own interests in LLCs or things of that nature?
If you have so when we look at estate plan, we look at all your assets, cash in the bank. If you have a life insurance policy, you have a retirement plan, or if you have multiple real properties, rental properties, and do you own an interest in an entity, whether a corporation, LLC, or partnership?
Yep.
or joint venture. Okay. So the very first thing I want to see is, all right, where's the proof of the venture or the entity? Your minute book? Oh, you don't know where it is? Oh, it hasn't been touched in 20 years? Okay, so we want to get those things current, because if something happens to you, capacity or death, now you've got documents that are not current, and they may have a problem. You're familiar with piercing the corporate veil.
Right.
If you don't maintain the corporate formalities, anyone else can say, well, gee whiz, you're treating it like your own pocketbook, so can I.
No, you have to memorialize the decision that the entity made, right?
Right, and it's very,
With
very
the
simple.
board.
It is so simple. Obviously, you file a form with the state every year. They just want to know who's in charge. But essentially, the shareholders appoint a set of directors. The directors appoint the officers, and they all approve of everybody's actions.
Yeah.
And this is a major transaction. You may put it in minutes as a special minute. But that's one of the most common things I find. And then there's another part of that, which is the fact that how do you own an interest in that? What's the proof of your ownership? If the corporation has a stock certificate. Gee whiz, they were never issued.
They're still in the binder.
Or we can't find them. Or there's a separate stock book, can't be found.
Yeah.
So we can order new stock certificates from a corporate supply kit, get those done, and get them, then transfer it into the trust.
Yeah.
But the question comes up, it's not just about you. It's about your partners. It's about your fellow shareholders and officers and your LLC members. Because if they have a member who can't do something, now they're all affected by it.
Right.
So it's very important to each member, each shareholder, and each partner to have some idea. Hey, gal, do you have something in place? Do you have a power of attorney over this particular interest? Is there a provision? Who gets this? I want to know. Is it going to someone that I don't want to work with? Because I want to work with you, but I may not necessarily want to work with the people that you're leaving this to.
Right.
I mean, I had a case one time where it was left to a second grade school teacher, and she really had no business acumen whatsoever, and it was a nightmare for the rest of the partners. So you need to think about more than just yourself in the process. You need to think about everyone who's important to you, and making sure that things can be done legally and properly. So I'm helping someone right now with a corporation and some LLCs. Well, a lot of things haven't been done in a long period of time. Mm-hmm. Somebody died 20 years ago. And someone else is collecting the money all these years. Mm-hmm. I mean, I see all kinds of things.
Yeah.
I mean, so it really, when you sit down with someone who does this kind of work, and a lot of accountants are very familiar with the need for this, because essentially they want to make sure they're filing the tax return for the right party, or the right entity, and the right pass-throughs, and all that good stuff. But essentially, you want to take a look at one moment in time. What actually do you have any interest in? Is it, everything from, like I said, bank accounts and stocks and bonds, entities that you're part of? I mean, do you have an employment contract? Do you have a stock option? Do you have some type of buyout agreement with your partners and co-shareholders? Do you have a prenup with a prenuptial agreement with a prior wife or spouse that has some provisions that affect your estate planning? In other words, when I sit down with someone, I want to get a complete history track record, and it basically forces people to gather all these documents, which if something happened to them, you might never see.
Right.
You might have a problem getting. So let's assume somebody dies and the spouse says, I think there was an employment agreement. Well, how easy is it going to be to get from the entity the copy of the employment agreement? How easy is it going to be to get some of these other agreements that were done, stock options, etc.?
If it's a small business and you end up in an adversarial position, very, very difficult to get those things.
So one of the things I say to the spouse who's not involved in the business is that this is protecting you, making sure you have your spouse copies of all the documents your spouse is engaged in, then you've got copies in case something happens, so you don't have to ask for them.
Right.
So this is all part of this process. And when someone has a life insurance, a retirement, okay, give me copies of the current beneficiary form and give me a blank form. Because essentially, I'll tell you something that's very important. Beneficiary designations are very important. Sometimes beneficiary designation, husband and wife, they'll name each other and then they'll be silent. Or they'll name the kids, as an alternate.
Yeah. But
the problem you have is that people have a lot of money tied up maybe in insurance, or a lot of money tied up in a retirement plan.
Yeah.
So if we're governing just the hard assets in the trust and will, we've got to sort of tie it together with respect to that beneficiary. So what I do is something like an asset schedule, a beneficiary schedule. So I say on the form to people, See Schedule A attached, primary beneficiary. See Schedule A attached, contingent beneficiary. And all that I sort of do a mini will on one page or more sometimes. Spouse, no question. Okay. But if for example, with life insurance, we don't want to go to spouse. We wanted to go to the trust. Why we wanted to go to the trust? The very fact is you could be in a joint accident together. So you want it in the trust, and then there's incapacity on the part of the survivor. So you can see you want to identify all these risks and do something about it. But also you might have some young kids. Well, you certainly don't want the couple $100,000 insurance going to the kid, directly. Now there's a guardian ad litem, and the guardian of the estate has to be appointed by the court. They get it at age 18. Not good. So essentially, what I'll say is that Smith or Jones Family Trust, whatever it may be, 1/3 share to Johnny, and if he's under 35, it goes to his trust inside the trust. I do the same thing with retirement plans with the conduit provision. Mm-hmm. So they get the required minimum distribution, but essentially you're keeping the assets all in one place so that there's not something falling through the cracks and going directly to the person. But what's really important in that is that it's very simple to say, let's assume you had 3 kids or 4 kids, and let's say they're all adults.
Yeah.
So you say, okay, here's this insurance on dad. I leave it all to mom. No problem. Okay, forget the trust for the time being. And then you leave it to the kids. Well, gee whiz, kids are now married. Kids have kids. Okay? Now, one of the kids dies. Does the insurance go to the 3 kids? And the child who died, their kids get 0? This is the stuff that's out there when I look at beneficiary designations. So you want a beneficiary designation that kind of mirrors your complete disposition, because this child, 1/4 share to Susie, 1/4 share to Johnny, 1/4, or their issue. This is all part of what I do in a beneficiary designation as a schedule attached to it. So nothing falls through the cracks. And one of the common things that I don't like leaving chance to chance. So when I do a beneficiary designation or do the attached schedule and sign it and then tell them to take it in, I say, give me a copy of it as received by the insurance company. Send it certified mail and have proof of delivery. I say, you can't leave chance to chance in these things.
Yeah, I've heard these insurance companies, big companies, they buy each other all the time, right? And then there's data migration. So as unlikely as people think it is, sometimes some information gets lost, whether it be like an updated beneficiary form.
Easy to happen.
Yeah, the insurance company, all they really care about is the original contract so that they're getting their premiums, right?
The premium is the most important thing to an insurance company, and not paying anything out.
Yeah.
No, I just had a little thing myself where I had a small account with something called Share Builders. It was part of Capital One Investing. Well, they sold their whole business to E-Trade. Now, I needed the document. Couldn't get it.
Yeah.
It's now going to take weeks to get the copy of the document, the 1099 for last year. But these transitions occur, and after a while, you can have a real problem.
Yeah.
And, finding things. So not everything stays available on the internet.
Yeah.
We might think it does, but things happen.
Yeah.
So getting that stuff, and if you're coming into a situation where somebody's incapacitated or someone dies, now the family or spouse, family, whatever, is in a hurry to say, what do? We don't want something to fall through the cracks. All right. If there's not complete record keeping, if somebody didn't get a moment in time of all the assets there were, they got to spend a lot of time trying to pull that back together, waiting for the mail to come in. What happens if you have an online only access and you didn't share your passwords?
Nobody has access to it, and you're
that's
on
right.
a timetable. Yeah.
This is a problem. I mean, what happens in our markets today? The stocks go up and down, don't they? So your financial advisor could say, you know what, let me get you out of this. If a person's incapacitated and doesn't have a power of attorney, if a person dies and doesn't have a trust, now you've got a situation where no one has authority for a period of time.
Yeah, and your assets are
could be
plummeting.
You could be in the middle of a lawsuit.
Yeah.
You could be in the middle of a sale of a house or purchase of a house. And it's frozen.
Right.
And that's not good, because the other person could sue you. Say, wait a minute, specific performance. I'm buying this house. All my affairs are all tied up, and you can't sign on the deed because you're incapacitated. Mm-hmm. That's not my fault.
Right.
Or died. So essentially, these are the kinds of things that if you're using a trust, you got successor trustees step in right away.
Yeah.
All these things. So there are so many ramifications and so many benefits of hitting addressing so many risks that people don't think, well, oh, that's never going to happen to me. But it happens to everybody. These things happen across the board. There's victims of illness and crime and, accidents and whatever it may be. And there's also death. So you've got all these situations. Now, for example, let's assume somebody out there has a power of attorney and then has a trust. Okay, so the power of attorney, a lot of power of attorneys are what they call springing. You've heard that term, springing power of attorney?
No. Explain.
Oh, this is very important, very important.
Okay.
So there's two types. With the power of attorney, you can have a general power, covers everything. Of course, it's got to be listed in there. There's some power of attorney done by the state and other documentary firms that have checked the box, real estate transactions, financial transactions. What does that mean? What does that mean?
Yeah.
So I spell those things out. This document is like 20-some pages. But essentially in this process, if you could have an accident and you could be in the hospital and you're intubated so you can't talk. Mm-hmm. They've got you strapped down because they don't want you to pull the thing out, right?
Yeah.
And now what do you got left? You can blink your eye once for yes and twice for no. All right?
Yeah.
Now you say, gee whiz, this power of attorney said on his or her incapacity, but they're not incapacitated because we're looking at mental incapacity. There could be physical incapacity. So a lot of times if I have couples who've been married a long time, nuclear family, 20, 30 years or whatever, people who are living together, close friends or whatever they may be, parents, children, I'm going to make that power of attorney for healthcare, for example, and maybe the other one, immediate. So you don't have to prove incapacity. And number two, you can overcome the fact that when there's physical incapacity, not mental incapacity. I mean, when you do this for a period of time, you see so many situations where you've got to build a bridge over a problem because somebody's got to do something.
Yeah.
And the whole part of an estate plan, when you do a complete estate plan, you've made sure that no matter what happens, somebody can do something and they can do it fast. And that's worth a lot of money. It's not just saving money going to court because, again, conservatorship is a public situation as well. Where, so if you have, let's say you're a kid, and I'm getting off the subject a little bit here, but I've had people come in, they have 4 or 5 siblings, and let's say they don't get along with most of them. If you go into court, every single child, regardless of your relationship, has the equal right to serve as your conservator.
Right.
You go, whoa, I don't want that one because the person you probably like the least is probably the person who's going to step up to do this.
Right.
I'm going to get even with this.
Oh,
I
no.
mean, you can imagine so many scenarios in this whole process.
Yeah.
So essentially, perhaps making powers of attorney immediate where you really trust that person. Because when you get a situation where, I'll wait till incapacity. Well, normally we have a court determination of incapacity or let's say 2 doctor's letters. No one has an idea how hard it is to get 2 doctor's letters.
Agree, yeah.
To say that this person, and then write it in the right way that matches the terms of the document. Not able to take care of your person or your property, et cetera, et cetera. They don't like to write them. So I have found over time, I've written many of these letters for the doctors and sent them out to them, say, you can put this on your letter, do whatever you want, but here's what I need. So you never know what you're going to find.
Yeah.
In this whole process. One of the things that you have to mention is tax issues with respect to trust and how people did estate planning.
Well, yeah. Ago. Well, previously, right, there used to be. Nowadays, there's a large estate tax exclusion, right? So it's over $10 million per person. So right. A married couple filing joint, over $20 million. So most people are never going to have to pay estate tax, or most people's estate are never going to have to pay a tax,
right?
On their heirs. There are select few, the top 1% who would have a taxable estate, we call it, right?
Right.
Prior to the $5 million exclusion, there used to be a $1 million exclusion, right? And there were trust structures set up specifically to take advantage of those.
Absolutely correct. What was happening, and these for the 99% of the time, we were drafting trust to try to preserve the exemption of the first spouse to die.
Yeah.
So, for example, if we didn't have any, like in California, there's no inheritance tax, but if we didn't have an estate tax, most people would say, I leave 100% to my wife, I leave 100% to my husband. Then we leave it to the kids. That's exactly what they want to do. And then all these benefits of avoiding probate and having it simple, having it private, those are all there. But so we would draft either an A-B trust, what we call it, above the ground, below the ground, or an A-B-C trust. In other words, what we really wanted to do in that process is grab that exemption for the first spouse, because before 2012 or whatever it was, that exemption disappeared. And if you left everything to your surviving spouse, he or she only had one exemption. And now all of a sudden your house and a few other assets, and you got a federal estate tax.
Yeah, you're up over $1 million.
So what you did, the only thing you could do is you said, I'm going to use my exemption on death if I die first, put it in trust for my surviving spouse, and then it won't be subject to estate tax. And then he or she would have their estate tax to deal with. But we now have something called portability.
Right.
Where if you, in the document, the surviving spouse can say, hey, I want to grab my spouse's exemption and add it to mine. And in which case, we're back to the situation where our planning should be much simpler in, let's say, a nuclear family or a simpler situation, where I can say, I give everything to this person, and I'm not worried about, say, if I'm leaving $50 million, yes, there's a state tax. But if I'm leaving $22.8 million right now, or whatever the exact number is, plus COLA, I have no problem. So that's fine going forward, because a lot of my trusts now will say, I leave everything to the surviving spouse with an option to disclaim for particular purposes, but everything to the spouse. And the spouse continues to trust, and it continues to be revocable. But on the other hand, if you look at people who drafted things years ago, it was the easiest thing in the world for an attorney in some of these firms that did it, and some of these mills that did it. Essentially, they gave everybody an ABC trust or an AB trust because they were covering themselves. Now, that person didn't go back to a lawyer for 5 years, 10 years, 15 years, 20 years, 25 years.
Yeah.
Somebody dies. And now the trust says there's no, oh, by the way, if there's no estate tax, we don't have to do this. No. It says you can now, the surviving spouse gets a revocable survivor's trust. The decedent's half has to be going into an irrevocable trust with all kinds of negative tax consequences and costs for maintaining it separately.
Right.
So that's a whole big issue right now, because you can either go to court to try to undo that, or if there's enough flexibility built into the trust, we can collapse that by agreement of all the parties.
Yeah.
There's ways of doing that. But essentially, it's much better to do that, while one of the spouses is alive, as compared to trying to, on the second death, to try to say, wait a minute, there should have been two trusts. Because you know the problem with having a trust created on the death of the first spouse. Low income tax basis.
Right.
So essentially, not only do you have an annual income tax return, which may be good if you're accounting for them, but on the other hand, you've got a low income tax basis, which creates additional capital gains tax. Because if the society is rising with inflation all the time, then you have one of your assets have a reduced basis and depreciation on it, bringing the basis down further. You are creating a capital gain for your heirs.
Right.
And in California, it's pretty rough. So essentially, looking at existing documents, anything that's been done, well, depending on who you went to. If you did a major firm, you did with someone who's got a good reputation, you're probably okay. But if it's been more than 5, 6, 7, 8, 10 years that you've done it, you really should have it reviewed.
Yeah.
Because you've got a problem that you don't even know about that's sitting in there.
Okay. Let me try and break this stuff down into a couple of different things. Simplify some of the concepts for whoever's listening to this, and then also maybe have a couple of action items for people.
Okay.
So first thing that people have to understand, right, is there is a step up in basis, right? There's this concept which is called step up in basis for heirs of a decedent. So somebody dies with something in their hands that for tax purposes, the basis of that piece of property steps up to the fair market value on the day
or down.
Or typically not down. Well, typically not down if it's real estate, right? It's almost
residential real estate,
always usually up,
right?
And real estate is
most stocks,
yeah, or they could become worthless, I guess. But most assets that are worth holding on to have appreciated over time. Person dies with this asset. And, it was a property that they bought back in the 60s for $50,000, and today it's worth $1 million.
Right.
the heirs to that property are treated as if they had purchased it for the $1 million, the fair market value.
At the date of death of whoever they inherited it from.
Right.
But there is one wrinkle on that that's very important.
Okay.
Husbands and wives. You've heard of qualified joint tenancy?
Yes. Uh-huh.
Okay. The problem with husband and wives is that if you leave it to your spouse, let's say in a joint tenancy situation, or if it can be inferred, only half the property gets a step up.
Okay.
Okay,
Yeah.
now, which militates in favor of someone in a community property state like California, of holding those assets as community property, both in the trust or if it's outside the trust as community property with right of survivorship.
Would you consider that like joint and several type ownership, or in any case? So in California, because it's a community property state, if you hold title correctly. One of the spouses dies, the other spouse actually gets a step up in basis of the full property
on
value.
their half as well as the half they
Right,
inherited.
100% of it.
And that's important for a lot of people with rental property, because then you get to redepreciate the property going forward, or you get to sell and get out of it and cash out with no
not paying
tax to speak of,
Yeah.
except for any gain after the date of death.
Right.
So that is so important. That's another reason to look at title, because people will say, hey, I was in the trust, I took it out of the trust, and it was put in joint tenancy by the lending company, and we forgot to put it back in the trust. Because so everyone comes in, I pull title on every single piece of real estate when someone comes in to see me, and I find a lot of problems. Not only was the trust titled wrong, but essentially it was taken out for refinancing purposes, or there's some other cloud on the thing that we will catch up on. I'm not a title insurer, but you almost have to act like one to do a good job, because real estate is a major asset, and of course retirement plans are a major asset.
Yeah.
So you got to put the time into both those things and do them clean. I do another step for property tax purposes. I don't think a lot of people do. So let's assume you had a trust, and then let's say the survivor does a new trust, or any two people. I generally don't take a piece of real estate and go from trust to trust, because now the tax assessor's office is going to look and say, we got to understand the first trust, and we got to understand the second trust, and we have to try to figure this out.
Yeah.
So every time that I do it, I sometimes do double deeds. So if someone comes in with a joint tenancy deed, I do a deed from husband and wife joint tenancy to husband and wife as community property, and then I put it into the trust.
Yeah.
Or number two, with respect to taking a property out of an entity, instead of going to entity, trust to trust, entity to trust, I generally go from the entity to the person. Okay, married, single, whatever it may be. And then from that person into their new trust. So that the title company and the tax assessor got it. I understand what happened here. There's no mystery about it.
Right. The chain of title.
That's right.
Who owned what.
Right.
So step up in basis is a really, really great gift of the tax code to heirs.
Oh, absolutely.
Huge. Right. Next, we talked a little bit about portability, which is the ability of one spouse to leave their $10 million plus exemption to their spouse. So there is an estate tax if you're fortunate or unfortunate enough to have to eventually pay it.
I would say fortunate.
If your assets are above 20 million,
Yeah.
But either in any case, which is that the estate tax is what 40%.
Right. The margin rate is 40%.
40%, and so which is a sizable amount, especially when you're talking about those types of numbers. And so portability must be elected. People don't realize that it doesn't just transfer.
Well, there might be a reason not to elect it and just use it again in, like, say, a bypass trust or something. Maybe we've got issues with respect to land and some contamination, or we've got some other issues where we might want to segregate because maybe the survivor's got a creditor problem. By making it his or hers, the survivor, maybe there's a lawsuit going on.
Yeah.
So you got to look at things, pretty carefully in the process. So, there's never a 100% answer. It may be a 99% answer.
if you want it, you have to elect it, and you
Right.
actually have to elect it on the tax return.
You do.
But what you're talking about is if there's something with an asset or something with a cloud on it, you might want to segregate that.
You
into
might want
like
to
a separate-
segregate that in
Yeah.
like a disclaimer trust or something else like that, where essentially use up some of the exemption, but you get that away and protect the rest of your assets from that bomb.
Yeah, ticking
Okay.
time bomb. Yeah,
Right, exactly. But one of the things that so there are income tax situations. What I've done in both my powers of attorney and my trust now, during the lifetime of the person creating the trust or husband and wife, both alive, I put a whole section allowing the trustee to make gifts. And I have, the purpose is not just being the plan for estate taxes anymore, because that's gone away for most people, but the plan for income taxes, property taxes, gift taxes, etc. So that gives a whole lot more options from the standpoint of making lifetime gifts, which may set up the beneficiaries, advancing some of their inheritance, let's say, which really puts them in a better situation, because property taxes are really a big factor here in Orange County, particularly if you're inheriting a residence or rental properties from a parent.
yeah,
Now, if I have a time, I want to mention that a few of this, because this is very important. Okay. There's an exclusion between spouses, which one can imagine, so that any transfer between a spouse is not a problem. There's no rise in property taxes. It's
Right.
not reassessed. There's also a parent-child exclusion
right.
for residents, no reassessment. And then that's for a principal residence. Anybody could be a $1 billion house.
Yeah.
No problem. Now, on the other hand, with respect to other real estate, let's say you have rental real property, business real property, commercial, but there's some changes coming perhaps on the commercial industrial property. But putting that aside for the time being, because that's going to be a probably. Putting that aside, let's say you got a couple kids. If you leave the one kid, no problem. Okay? But each parent has the right to leave $1 million worth of assessed value for the parent-child exclusion with respect to non-primary residence property.
Wow.
And if you miss that, and you've got people whose total portfolio is real estate, this is a big issue,
Yeah.
because it's the assessed value, which could be worth multiple millions for that million. So I always have to see property tax bills, okay? And part of the thing I put in there, so if you say it's just, you know what, I leave everything I have to my 4 kids in equal shares. Wonderful. Everyone's treated fairly. Now, what's the problem you have in the trust with it? Let's say and I've seen people do this, they write the deed out. Okay, 4 kids, here's your share, Johnny, Susie, Brian, Denny, whatever. Here's your shares. Now, one says, I really don't want my quarter share in this property. How about if you buy me out? If they do this outside the trust, property taxes go up when a sibling buys another sibling's property.
Right. Yeah. Change the title. Yeah.
Exactly, a change of beneficial ownership. But inside the trust, and I put options in there and allocation against shares, so that before the real estate is distributed, inside the trust, we can say, let's say I had $1 million piece of real estate and there's 2 kids and $1 million in cash, and one of the kids wants the property. So essentially, the trust internally will allow the kids to elect to say, I'll take the property and I'll get the full parent-child exclusion. You take the cash.
Yeah.
And I'm oversimplifying it, but there's other options that we can think of. So, for example, when you have an estate that's, let's say the property is the entire estate, well, you obviously can't give the property to one kid. Mm-hmm. So now you're going to have to go out and borrow money inside the trust for the $1 million property to bring it down to $500,000. So you got $500,000 in cash that was borrowed, $500,000 property net equity, and then you give it to the kids and you preserve the property tax exemption.
Yeah.
So this property tax exemption, in a lot of cases, and people don't sell their properties because of the property tax lots of times, it's really important that be going over thoroughly. Do the kids want the property, or at least have the option to take the property, and take that exempt and preserve the tax exclusion between parent and children, because that's thousands and thousands of dollars a year. And if you have a rental property, that could be the difference, or a residence, the difference you keeping that property and or renting it and then having lower expenses.
Yeah, cash flowing and not cash flowing.
That's right.
Yeah.
Right.
Really, really big. Yeah. And wow.
I can't do estate planning without doing property tax planning.
Especially in California.
Especially in California. Other states are pretty much, the properties are reassessed, and you can't do that much about it. But one of the topics that I wanted to mention briefly today was my concept of legal strangers.
Oh, okay. Yeah. So unmarried couples.
Unmarried couples.
Okay. Yeah.
I mean, many people are living together. Yeah, I mean, even at older ages as well.
Yeah.
So you have situations where they may have lived together without getting married for 10, 20, 30, 40 years.
Yeah.
As far as the law is concerned, there's no provision for an unmarried person in this document.
That's interesting, right? Because people throw around the term like common law marriage.
There is no common law marriage in
Yeah,
California, and there's no longer a common law marriage in almost every state.
Yeah,
It's been abolished pretty much everywhere.
Yeah.
Okay, so they fall back as a sort of a common concept that doesn't exist.
Yeah.
So essentially, if for example, let's assume and I had a guy come in to see me, and he had a girlfriend, and they're both living in his house in Newport Beach, and essentially they didn't want to get married, whatever reasons. So I said, well, what about registered domestic partnership? And they thought about it, and they did it. Mm-hmm. So now she'll be able to inherit the house, which she's supposed to do, and keep his low property tax basis. And that's not a technical marriage for other purposes, but it is for this purpose. Yeah. And then if you're don't want that public, you can file it in a way that's kept private, so no one really has to know.
Yeah.
But getting back to legal strangers, you're living together. There's a medical emergency. Someone's got to write a check out of an account. Now, obviously, you can handle this stuff with powers of attorney and trust and wills.
Yeah.
But if you don't have it, that person's on the outside looking in, and the family member they don't like now has all the legal rights. So I would say that it's incumbent on anyone who's single, anyone who particularly, and anyone who's living in an unmarried situation where they're really being close and will be close and continue, and particularly where they have kids together, they need to do this.
Yeah.
Okay, because we can do anything they want as long as it's written down, signed, and notarized, etc.
Yeah.
These are not hard to handle. All you got to do, the government says, put it down, write it, do it the proper way, we'll honor it.
Yeah. Two adults with capacity to make decisions, and you're memorializing
There isn't
it.
much I can't do with the documents that they would want to do, as though they were married almost. But if they don't do it, you can imagine a worse situation where you're sitting outside, you can't even talk to the hospital nurse, the doctors, or anybody.
Yeah.
I mean, and that's just the start of the problem, So this stuff is very important, and you don't have to have a lot of money. The powers of attorney alone, just to be able to manage your health care, I mean, that doesn't mean, who cares about how much money you have? You want to take care of yourself, and you want to make it easy for someone to take care of you. Mm-hmm. So it starts with kids over 18. It starts with people living together, and it goes from there for everybody.
Yeah.
Adult children who are off, living, got divorced, or let's say you got someone who's who's thinking, I may get a divorce here, a legal separation. Well, the very first thing that you want to make sure is that he or she is not making my medical decisions.
Right.
Maybe you have a power of attorney. You name him or her as your first agent for healthcare. But now you don't trust them. They're having an affair. They're doing this. They're doing that. They don't want to... all these stories on TV about the people who want to avoid divorce and they do horrible things.
Right.
Okay. So the very first thing is you want to go do your own private will and powers of attorney, which you can do. Once you file a petition for divorce, you can't change the trust. But you can do powers of attorney and a will on the outside, and that's not a problem. So there's just so many things in life that this touches. Yeah. And most people say, I guess, I've even had, you're going to laugh at this, I even had two accountants ask me who I've known for a long time, and they said, I guess I should be doing a trust. And they're in their 50s or 60s, and now there's some health problems. Like, this is the time you're starting to think of doing this?
Yeah, they've been practicing for 25 years.
Exactly. I don't know. It's just that you see a lot. You learn a lot about human behavior. You learn a lot about assets. It covers every single asset or right you have.
Yeah.
And essentially, there's tax consequences if you don't do things the right way or don't have the power to do things the right way.
Yeah. Why do you think a lot of people don't do estate and trust planning? Because you're touching on a lot of things.
Yes.
Some people have a hard time discussing their own mortality. They're scared of it, and then some people fear having to write the check for the attorney to actually do the work. Well,
these are good points, but essentially, if you can write a check for your insurance on your house, your earthquake insurance, your car insurance, your E&O insurance,
Yeah.
then I think you can write a check to do your statement, because this is legal risk management, legal insurance
Yeah.
in a sense. Okay. So the first thing when you look at risk is you need to know what the risks are. And a lot of people are walking around not knowing what the risks that they're just assuming will not happen. And the more people there are in your life, the more risks there are.
Yeah.
It's going to happen to somebody.
We call
Or
them
let
loose
alone-
ends.
They call them what?
Loose ends.
Loose ends. But this is a great exercise from your own standpoint
Yeah.
of getting a handle on what you have. And regardless of whether people like to think about it, they know in their head that I've got something undone. And that's another little wear and tear that you're carrying around with you. And it would make the other spouse feel good that you're thinking about them, caring about, and you should make you feel good and make your kids feel good, and make them part of their growing up. They need to know this stuff should be done.
Yeah.
Okay, so it has a lot of good on it. And if you look at the cost of doing this right compared to the cost of not doing it right,
Yeah.
it is just like insurance. It's just like a fire or something. It's open-ended. The circumstances you could find yourself in incapacity or death, where you could lose most of your assets. There's someone we know, both know, that said he had a friend, all his everything, he had all this real estate. He was on papers worth a couple of $1 million. All the property was lost. He had mortgages that weren't paid. No one could find them. Everything was done online with passwords.
Yeah.
And, I bring up all these issues with people because I try to identify all the risks that I can. And obviously there's not every risk can be identified, but there are minor risks. If you've identified the major ones and set something in place to allow someone to handle it, then you can address the minor risks that are out there. But essentially, I used to joke with people and say, they'll go out and they'll spend $3,000 or $4,000 or $5,000 on a refrigerator.
Yeah.
They'll go without even blinking an eye, or same thing on a sofa or more. But their estate plan, all their assets, their spouse, their kids, their grandkids, their parents. So one of the things, how do you put a value on this?
Yeah. For the cost of a decent couch.
I said that something. I make people laugh when I said a decent refrigerator with all the bells and whistles.
Yeah.
It's not much more to do the job right. But a lot of people. There's another thing. That a lot of people don't think about. Let's say someone's in their middle age.
Yeah.
They've got adult kids and they still have their parents. And a lot of times the parents may not be that well off. So what are they doing? They're letting the parent live in a house that they own.
Yeah.
Right?
Yep.
Or they're sending
That's
mom
very
or
common.
dad
Yes.
$500 a month as a gift, or $1,000 a month. God forbid they die. Let's say they become incapacitated. Well, there's no power to continue that. It stops. Okay.
Yeah.
One of the questions I ask people: are you doing anything for your parents, or brothers, sisters, or anybody? Or if you're not, do you think you might have to do that in the future?
Yeah.
Let's put some permission in there. Okay, so let's take another worst case scenario. Person dies. Mom's living in a house. So now the trustee has got everything set in trust for the kids, let's say.
Mm-hmm.
There's no provision allowing mom to live in there without paying full rent.
Yeah.
Do you see what I mean? So mom's got to leave.
Yeah.
I mean, the kids, and let's say the kids are minors. They can't agree. Right?
Yeah.
So all I'm picking out is these there's so many things that can happen. If you look at where you are in the trajectory of life from being, let's say, 18 forward, or the people, your spouse, your kids, your parents, brothers and sisters who are friends, people you're living with,
Yeah.
unmarried relationships. You've got a whole panoply of people, a whole panoply of assets, and there's risk that's sitting out there on all of them, and the ability to sit down and address that gives you a sense of control. Gives you as much as you can have control in this life, but it gives you a sense of peace and control that you've addressed it, and then you tweak it every 5, 6, 7 years. You can sit down because tax laws change, your relationships change. The person you name you may not like anymore. Your assets may have increased, they may have decreased. In either event, you still need planning.
Yeah.
Okay, even the assets go down in value because maybe you said, I'm going to give 100,000 this one, 100,000 that one, 100,000, and then balance I'm going to get. There's plenty to these people. All of a sudden, your estate has now shrunk to the amount of the specific gifts. What do you do then? Maybe you put a percentage, but 100,000, but no more than 5% of the estate. So these are things that I build in as well.
Yeah.
So you can see what I'm trying to get across is the fact that you have to just use common sense behaviors. You've got to look at what can happen from a governmental standpoint, a tax standpoint, and what can happen in life.
Yep.
And then do your best now, and then revisit it as you move on the life cycle in 5 or 10 years.
How often should somebody review their trust? So, action item: if you have an AB trust, you definitely 100% should be taking a look at it and trying to restructure a more efficient trust than that is. But how often?
Well, the thing is, there are certain triggers. One, I'd say, even if you don't think there's a trigger, 5, 6, 7 years, they should be revisited.
Yeah.
Because there's changes you may not know about. And number two, when I ask a person a question in 1 year and ask them 7 years later, I may get a different answer. They've matured. They think differently about the people. Relationships have changed. All kinds of things have changed. But on the other event, if something's happened that's changed, you've had a major life or death, and in the family, you've had illness or something. You've got a kid with creditors. You've got all these things that can change. As soon as you have any of these major events, disturbing events in life, you should say, how does my document affect this? Is there anything I can do to bridge over it?
Yeah.
So those are the two triggers. One, if a fair amount of time goes by. But number two, if you have a document that has documents that haven't been drafted in, let's say, before 2012, let's say, okay, or 13, and you're going to find that I don't know, not just myself, but we ask a lot of questions. But our job is not to tell you what to do. Our job is to be your guide, identify the things, and then say, in one case I did such and such, and how does that sound? Make suggestions. And then you get the benefit of that time, experience, and exposure to things. And you can walk out of there feeling, good, I got this put aside for the time. I've done what I could.
Yep.
And that's a good feeling. But getting back to the parents for one standpoint. So Gabe, if someone named you as trustee of a trust,
okay,
and I'm sure you probably have been named.
Sure, yeah.
Probably. That's life. People like their accountants.
Okay.
Okay, they trust them.
Yeah.
Anyhow, so, you may look at the document. What I would say to anyone's named trustee, you go and have that document looked at by an attorney, because this may not be something that you want to touch.
Right.
Okay? So one of the first things you want to do is make sure, is this, and the banks do this all the time. They'll just say, I'm sorry, we can't touch this. This is just too messy, too difficult, whatever it may be, because we can't make a living. And two, we don't want the risk. So each individual should do the same thing before they say sign yes. Someone dies, someone's incapacitated. Let me review this and think about it for a day or two.
Yeah.
Before I say yes, because otherwise, if you fail to serve, somebody else is named, and hopefully that is the case in that situation. But a lot of times when I have adult children and their parents are getting more and more elderly, I said, if daughter or son thinks, well, I think my mom has named me, or whatever to do this for. Well, do me a favor, bring in those documents if they'll share them with you.
Yeah.
So you have the power to do what you think you have the power to do. Let's make the healthcare immediate. Let's get an IRS tax power of attorney for this some person who's in bad shape. Okay, both FTB. I like it. I like doing them both. And let's take a look at the trust and make a suggestion. Hey, Mom, this doesn't really work anymore. You know what? I've made special provision for my kids, and the provisions in your trust in case I die ahead of time are not the same. Mm-hmm. Do you see? In other ways, there's conflicts.
Yeah.
So I sometimes go up a ladder and say, if you're going to be doing things for your parents, let's kind of look at their documents and see if there's anything glaring. Because a lot of times people go, they just don't touch things for years. Oh, it was good enough for Dad. It's good enough for me. But they don't understand there's a difference between one spouse dying and the second spouse dying. So then the latter situation that I actually get into is, let's say, Mom's got 5 kids. Dad died a while ago. And one of the kids is living in the house. Very common. And sometimes it's the son who hasn't done that well in life.
Yeah.
Okay. So Mom,
millennial.
It could be. It could be even older.
Yeah.
And then he goes out and he uses their cash card. He doesn't. Everyone kind of knows about upset. And then Mom dies, and then he won't leave.
Yeah.
Okay. In another case, he was the trustee. Okay. So anyhow, when I have someone, let's say in their mid to late 80s, or depending on health, and we're doing something unusual. Let's say we're not going 5 kids, 5 shares, 4 kids, 4 shares, 3 kids, 3 shares, 2 kids, 2 shares. You know what I mean?
Yeah.
I'm going to give the house to this one, and the rest of it gets divided among the rest of you. Now, of course, the house could be this, and the other assets could be that. So what I've taken to doing is that I have them visit a neuropsychologist who then basically writes up, said, yep, they're competent, they know what they're doing, and they do want to do this, and that goes in the file.
The document's more enforceable.
Yes.
Because of that.
Exactly. Because
Yeah.
if you do something unusual and you're drafting this document, you don't want to be on the stick from the standpoint of I'm not a psychiatrist, but I might know that somebody's not competent.
Yeah.
Or marginally competent, or even if they are competent, someone could allege that they're incompetent.
Yeah.
I have seen this happen. So therefore, the insurance policy goes in to the file. Okay? She knew what she was doing. It was explained to her. She took all the tests. She had motor skills. She had this and that and the other thing. And that's fine.
Yeah.
You know. But of course, you get into things like disinheritances. You get into other things in the situation. It just goes on and on and on.
Yeah.
It depends. So each person that comes in, this is kind of like a decision tree. I may ask them one question and not ask another question because I've already eliminated that other question
As an option, yeah.
in the process. So gathering your information, who are you? Who are your family? What are your relationships? What are your assets? Do you got copies illustrating all these assets? You know, whatever, particularly if they're private companies. Copy your tax return. And now let's sit and have a discussion. Tell me what your feelings are. And then I'm going to ask a number of questions. If you can't answer them, you can get back to me. But then you're going to review this draft. I'm going to send it out to you with no cover letter. I'm not going to give you a set of instructions saying, here's what it says. You read it. Because someone's going to read this when an event occurs.
Plain English.
Well, it's as plain as we can do because we have to write for other lawyers too.
Right.
And judges. But essentially there's little tricks in drafting. Double spacing things, making sure there's no run-on sentences, capitalizing names, putting relationships down. There's all kinds of practical little things that I think make a difference because when I reviewed a document, who is this person? Who is that person? Well, maybe they remarried, they got a new, but I don't know. Maybe they're a friend. Maybe who knows who they are?
Yeah.
I find this all the time in poorly drafted documents, and I also find it with people years ago who went to these financial seminars and are selling annuities and things like that. Oh, we'll do a trust for you. And it is horrible documents. And they think, oh, I did a trust, well, I'm fine.
It's a trust mill. Yeah.
Yeah. And that's really a shame because every person who comes into me comes up, I never know where they're going to end up. I never do.
Yeah.
I might have an instinct, but it remains to be seen after they're asked questions and we deal with their answers. So I think it's really, really important to have something. Each of us is unique medically, and each of us is unique legally.
Right.
And there's no way around that. We're not all cookie cutters. We don't make all the same decisions, and all the same things don't happen to us. You know? And all our relationships are not perfect. One way or the other. I always worry when somebody says they get along, everyone gets along. Then I'm almost sure there's problems.
They just don't want to talk about them.
Well,
so
sometimes people tell you too they've got unusual situations and sometimes they don't like to talk about it. I said, look, whatever you tell me is grist for the mill. Just like you tell a doctor, your priest or minister or something like that. This is grist for the mill. I won't be thinking about this a week later.
Right.
I'll send them out to you, and I'm moving on to the next thing. You know, so the job is only as good as the information you get and the questions that are answered.
Oh God, do I know that? Yeah.
Yeah, you know that. You know that.
Yeah.
You know, bringing the box in with all the information. Now you figure it out.
Exactly. Yeah.
You know, do I have everything? What is this? Maybe I've got an old document. But I do ask for copies of things. And then, of course, which helps me in what I do is I've done a number of probates, and they're not that easy sometimes. There's issues. And number two, I've done a lot of trust administration, which means I've got to get that property, distribute the benefit, and have them sign off on it. All my trust administration has been done without going to court. Not a single one ever went to court.
I think that's an amazing accomplishment.
I'm amazed by that myself. That basically
in your long career, wow.
So you have to put yourself on the side of the other. When you're doing something like that, and you want someone to do something, you got to put yourself in their shoes. And think about what they're looking to. Because essentially, a lot of times you have married couples or kids, well, they got their husband or wife chattering in the ear while you're on the phone with them, you know, whatever. And getting things down in writing. Because times most people want things to be over with.
Yeah.
So if you identify their issues and you don't light any fires, you generally will get to the finish line, no matter how bad the behaviors could be, So it's an interesting thing. You learn a lot about human nature, a lot about behavior, a lot about psychology, a lot about property. I mean, it's a cat's pursuit, just like you have.
Yep.
Because every year you got to look at what's there, what they did, and sort of report back to the IRS and the Franchise Tax Board. Here, I've got to, in a sense, putting all this together, try to make sure that the legal insufficiencies and taxes, whatever, that we have an efficient estate plan that works as far as humanly possible without a crystal ball. Because sometimes I have a old crystal ball that I got on purpose, and I said, it's not telling me anything. I need you to. There's no answers in there.
Yeah.
What do you think?
Yeah, exactly.
I mean, I'm happy to make suggestions and share every bit of experience I've had. But it's interesting. People do take a lot of guidance in the process. Is there anything where we have any good stuff that's left on this?
Let's see, we're at an hour and 20 minutes.
Oh.
We haven't really spoken about...
There's a couple little things in the back. We can go over these pretty quickly if you'd want.
I mean, we could also do another show,
Well, sure.
Yeah, we could come back in like a month, maybe talk about asset protection, which is a big topic.
Good.
Like how does that work? How does it not? There's a lot of estate attorneys. There's a lot of asset protection specialist attorneys out there, and some of the stuff is practical, some of it's not.
Some of it is just you're paying for nothing.
Yeah, you're not getting what you're paying, what you think you're paying for.
And also, I put in there, which I hadn't thought of before, and I haven't brought up in seminars before, is you got people moving in and people moving out. Yeah. For many reasons. And so that's another something that would be nice to go over because people wonder about that.
All right. Let's have you back then.
Well, that'd be great. I'd appreciate that opportunity. It's my first podcast. I survived it.
I think you did it very well.
Well, thanks.
I mean, the breadth of knowledge that you have is just you can tell. You can tell after 35 years of grinding.
Well, I did this in Pennsylvania a little bit too before I moved out here.
Yeah, you were a professor in Pennsylvania, right?
The background. I was an accountant before law school and then law school. But I made the big mistake. I remember at the time saying to myself, "I'm getting tired of numbers. I want to deal with words." And after years of dealing with words, I said, "That was smart. I should have stayed with the numbers."
With the numbers, yeah.
They're much better. They're much more in some respects, black and white. But no. Then I went on. I got the MBA from Wharton in finance and my combined law degree, and then a CLU at that time, the Chartered Life Underwriter, just to know about insurance. And then I did teach for 2 years at the Wharton Grad School, business insurance and estate planning.
Yeah.
So and then just been on my own pretty much ever since. Massive.
Yeah. Awesome. So thanks for being on the show.
Well, thank you.
How do people get a hold of you?
Well, I'm on the internet. My phone number or email.
Yeah, you can give a phone number, email.
Okay.
However people should get.
I've had a phone number, which most people probably can't say this, since 1981.
Okay.
Out here, 949. It changed from 714. 949. 851-9210. That's 851-9210. My email's a little bit longer, but it's my initial M Walsh altogether.
Yep.
Hopefully they can spell Walsh, WALSH, at Walsh with a hyphen, not an underscore, a hyphen, lawfirm.com. M Walsh at Walsh-lawfirm.com. My assistant is Linda Heimstra, and she fields all these calls and things. We have a questionnaire we use with people, set up a meeting, have a phone, get acquainted, because essentially I've got to delve into everything with you, and I want people to feel comfortable that we know what we're doing enough to do hopefully a very good job for you. The more thorough it is, the less likely you may make any changes.
Awesome. Thank you, sir.
Thank you, Gabe. Appreciate it. Thanks for the opportunity.